The first thing I want to talk about is just sort of reassure you a little bit. Since the Windsor decision, we've heard, well, last year we heard from about 1,500 same-sex binational couples from across the country and around the globe. Since the Windsor decision, we've heard from 2,500 same-sex binational couples with questions about what now, what now? What should I do? And so part of those questions has really been this sort of like, it can't be true. Like, no, yeah, we read your website. Yes, you answered my email, Tom, but I'm calling because I don't think it can be true. So a few things just to sort of this pinch me moment to just assure you this is really where we are. And so Immigration Equality has been working really in advance even of the decision with the agencies to try to make sure that when the decision came, that it was implemented as quickly and as thoughtfully as possible. And this is what we've heard thus far. And these are encouraging words. From Secretary Janet Napolitano, after last week's decision by the Supreme Court holding that Section 3 of the Defense of Marriage Act is unconstitutional, President Obama has directed federal departments to ensure the decision and its implication for federal benefits for same-sex legally married couples are implemented swiftly and smoothly. To that end, effective immediately, I have directed U.S. Citizenship and Immigration Services to review immigration visa petitions filed on behalf of a same-sex spouse in the same manner as those filed on behalf of opposite-sex spouses. So this came out like 48 hours after the Windsor decision. So the head of DHS, which includes a number of agencies that affect our family, said, no, this is for real. As of now, we're going to adjudicate these petitions for same-sex spouses the same way we do for different sex spouses. You also heard that the State Department plays a role in this in a number of different areas, including if a family's consular processing, if they're, and I'll talk a little bit about this, if a family's been separated, if they need to apply for a fiancé visa, the State Department will be involved. And so states implementing this is also quite important. So Secretary Kerry, which you guys should get a little credit for him, to fully implement the requirements and implications of the court decision, we will work with the Department of Justice and other agencies to review all federal statutes as well as the benefits administered by this agency. And the guidance, that was his quote, the guidance goes on that they are going to work to implement it swiftly and smoothly. So the initial guidance that we've gotten from the heads of the agencies that are key in implementing the decision is good. We are still waiting for further guidance, and I think that we'll go a little bit more into the details about how this is going to be implemented. But for most families, you can move forward at this point. You can begin to put together a plan. For many years, when families would reach out to us, we'd sort of give them the information they needed, and it didn't necessarily make sense to go out and get a lawyer if there just wasn't an option for them. For many, many families, there now are options, and it really does make sense to get an advocate who can work with you to explore what those options are. I'll also mention one other thing, another reassuring decision, is that on July 17th, the Board of Immigration Appeals, which is an administrative court which really sets the policy for USCIS, issued a decision in a case called Matter of Zeleniak. And the Board of Immigration Appeals makes decisions all the time that they don't publish, they don't make them precedential. But in this instance, the court made a decision and they said this applies for everyone. And what the Board of Immigration Appeals said is there had been a couple who had filed a spouse petition while DOMA was still around. And many of my clients were those sorts of folks who were, pushing before the government was ready to do the right thing. And so a spousal petition had been denied, and what the board said is, we're sending this spousal petition back down to USCIS. And what they specifically said is the decision in United States v. Windsor applies for same-sex binational couples. The other thing that they said is that this couple had gone to Vermont and been married in a marriage equality state, but did not live in a marriage equality state. And they said the the two issues, well, one issue has been acknowledged by USCIS. They were validly married in the state where they celebrated their marriage. Who cares if Pennsylvania's just there just yet? I think they're going to get there, but the point is, if you live in Florida, if you live in Pennsylvania, Texas, Nebraska, the USCIS guidance says it's the place of celebration that's going to be the operative factor on determining whether or not you're validly married. So the BIA sent this decision back down and said, really all you need to do right now is figure out that love or green card question. You know, sometimes you hear that referred to as whether the marriage is bona fide. And so take this down, move forward like you would with any couple, straight, gay, or otherwise, figure out whether or not they're doing this for the green card, and if they're not, give them their green card. So this is really great, another great decision. The BIA also said, because some of the guidance right now just talks about adjustment of status and submitting an I-130. The BIA in their decision said, and this Windsor decision, it applies in a whole bunch of different contexts. And in there listed the different areas of immigration law where the Windsor decision has changed the game, including some of the things we've talked about, and some things that we haven't gotten to yet, but like cancellation of removal was listed in there. Asylee derivative benefits were included in this sort of list of areas of the law that Windsor has changed for same-sex binational couples.
Can you spell that? Is it C-Y-L-A-N-I-A-K?
It is Z-E-L-E-N-I-A-K. And I just had a flashback to a really painful spelling bee experience. Sorry. That's okay. And the word was nowhere near as hard as Zeleniac. So the other thing I wanted to do is go over some of the questions, some of the frequently asked questions that come up. So with 2,500 questions coming in, I have a general sense of what most people want to know. I know each of your families are going to have different circumstances and different fact patterns, and that's why it's going to be important to work with someone who can give you tailored advice to your circumstance. But these are some of the sort of most asked questions. So I'll just tee them up and bat them down. Can LGBT couples get green cards now? Yes. The question of, and I've sort of mentioned this, do I have to live in a marriage equality state? No. If you need to travel to some place where two men or two women can get married. So if you can travel to any of the 13 states or the District of Columbia to marry. Also for families that are abroad or can travel, there's also about 15 countries around the globe where same-sex couples can get married. A follow-up question to that is, does a civil union or domestic partnership count? Because there are many places around the globe and throughout the country where you can get something that's pretty much the functional equivalent of marriage in that state, but isn't marriage with a capital N. And that question will probably be answered in the guidance that we're hoping we'll get in the next week or two. We have definitely been advocating that where a marriage is the functional equivalent, where a relationship recognition is the functional equivalent of a marriage, that it should be treated as a marriage. But in the US, we seem to really care about that name. And there has been guidance in some other areas of the law already where they've said that a civil union will not be treated. So the Social Security Administration has already made some statements about how they're going to, interpret civil unions, domestic partnerships, etc. So the jury's still out on that, I suppose. But for many couples who maybe have a civil union or a domestic partnership, if they can safely travel to a jurisdiction where there's marriage equality and get a marriage with a capital M, in most instances, that's probably a safer bet if you need to move forward quickly, even before further guidance comes out. There are consequences of getting married beyond the immigration context, though, right? And so while you may be able to safely travel to someplace where you can marry, it might be more difficult. It may be more difficult to get divorced in that place you travel to. The good news is you're in Massachusetts, most of you, or even if you're from neighboring Connecticut or pretty much neighboring most anything, you can get married where you are. Your state recognizes your marriage now, and your federal government will as well. My partner can't get to the United States, and we can't marry in his or her country. What are our options? Okay, so this is something that hasn't come up as much thus far, and we do hear from a lot of families where they can't get the foreign national partner into the United States. It's difficult to get them a tourist visa, student visa, etc. And they don't have marriage equality in their home country. So the standard process here is to apply for a fiancé visa so that the foreign national partner can travel to the United States to marry. And then within 90 days of their entry on the fiancé visa, then the U.S. they need to get married. And then the U.S. citizen can petition to sponsor the foreign national partner as a newly married couple. So that's going to be the process for most couples that are separated and can't marry in the foreign national's home country. There's also a number of countries around the globe where gay or lesbian couples can get married. Many of them have residency requirements. There's information on our webpage about where gays and lesbians can marry and what the requirements are in each of those jurisdictions, including all the 13 states in the district and the countries around the globe where same-sex couples can marry. Another question that a lot of people ask is whether they need a lawyer to do their application. And I know people are saying, like, where do I find the forms? And I don't charge anybody anything for anything I do, so I don't have a horse in this race. But I think that if a family can hire an attorney to help them through this process, in most instances, I think it makes sense to do that. Immigration Equality knew when this decision came that there would be a lot of families who needed help, and that we're not going to be representing 36,000 same-sex binational couples around the country. And so we put a lot of effort and initiative into building our referral list of immigration attorneys. Every immigration attorney on that referral list has participated in a training that really sort of looked at the little nuanced issues, really went into the weeds on what some issues could be for same-sex binational couples. And so if you are trying to find an attorney that you trust, whose focus is immigration practice, and who has experience and training on working with LGBT, HIV-positive immigrants and their families, you can go to our webpage and ask for referrals through our Contact Us link. There are 4 attorneys here in the room that I know are on our referral list, including your panelists. And so if you can swing it, I would get an attorney if you could. And if you can't swing it, there are a number of community organizations that do provide services for, if you meet certain sort of financial criteria. So if that's your circumstance as well and you're reaching out to Immigration Equality, let us know. And we'll try to give you referrals for community-based practitioners in your area.